How long does it take to sell inherited property? Selling inherited property can take as little as 2 to 4 weeks after legal authority is established, but probate, title problems, repairs, debt, or heir disputes can stretch the process to 6 to 18 months or longer. Here is the clean way to think about the timeline. Trust property and transfer on death deed property can move like a normal sale once the right paperwork is done. Probate property moves on the court's timeline. As is investor sales can close quickly, but only after the person signing the contract has authority to sell. If the property is in a properly funded trust, a clean sale may close in 30 to 60 days after the successor trustee is ready to act. If probate is required, an uncontested sale often takes 6 to 12 months, and a contested or complex estate can take 12 to 24 months. I'm Rhett Fruitman, co-founder of Inherited Property Match. My background includes Citi Private Bank, CBRE, and helping families navigate inherited property sales across the country. This is general information, not tax, legal, financial, or real estate advice. Before you sell inherited property, speak with a CPA and, when probate or trust administration is involved, an estate or probate attorney. What determines the timeline for selling inherited property? The timeline is determined first by who has legal authority to sign the sale documents, then by title status, probate or trust requirements, property condition, debt, insurance, and whether the heirs agree. The first question is simple. How is the property titled at death? If the property was in the deceased person's name alone, probate is often required. If it was in a revocable trust, the successor trustee may be able to sell without probate once the trust documents, death certificate, trustee authority, and title company requirements are in place. Can you sell inherited property without probate? Yes, if title passes outside probate. Common examples include a properly funded revocable trust, joint tenancy with right of survivorship, and a transfer on death deed in states that recognize TOD deeds. Transfer on death deed property can often sell in 30 to 60 days after the required state-specific affidavits, notices, or transfer paperwork are completed and recorded. Property already distributed to heirs can also move like a normal sale, assuming title is clear and all required owners sign. Why does probate slow down the sale? Probate slows an inherited property sale because the seller may need court-issued authority, notice periods, creditor claim windows, title clearance, or sale approval before closing. Probate does not always mean you must wait until the entire estate is closed. In many states, the executor, administrator, or personal representative can sell during probate once the court issues letters testamentary or letters of administration and any required sale approval is complete. How long does probate take before selling a house? In an uncontested estate, a probate sale often takes 6 to 12 months. In a contested or complex estate, it can take 12 to 24 months. Small estate procedures can be faster, often 2 to 4 months where they are available for real estate, but not every state lets heirs transfer or sell real property through a small estate shortcut. In some states, even an accepted offer does not mean an immediate closing. Court confirmation, notice periods, or overbid procedures can add weeks or months. California is a common example where heirs should plan for that extra time if court-supervised sale rules apply. What usually delays an inherited property sale? The most common delays are major repairs, one heir refusing to sell, title defects, liens, mortgages, reverse mortgages, HOA dues, insurance gaps, out-of-state logistics, and slow market conditions. What if one heir refuses to sell inherited property? If the heirs are already co-owners, all owners generally need to agree unless one owner forces a sale through a partition action. Before that, families usually try a buyout, mediation, or a written decision deadline. Title problems create delays too. A title company may find an old lien, unpaid property taxes, a deed defect, a mortgage payoff issue, or a property that was supposed to be in a trust but was never transferred into it. Debt matters because mortgages, HELOCs, reverse mortgages, property taxes, and HOA liens must be resolved before or at closing. As of 2026, for many HECM reverse mortgages, heirs have 30 days after receiving a due and payable notice to buy, sell, or turn over the home, and extensions may be available when the property is actively being sold. Vacant homes can also cause insurance problems. The existing homeowner's policy may not be enough once no one lives there, so heirs should confirm coverage before listing, showings, or clean-out work. How can heirs speed up the sale? Heirs move faster by confirming authority early, ordering title work, getting a date of death valuation, resolving debt and insurance issues, and hiring a broker who understands inherited property sales. Want fewer surprises at closing? Start with authority, title, and value. Authority means the executor, administrator, successor trustee, or titled heir can legally sign. Title work catches liens and deed defects before they become last-minute problems. Value helps with pricing and tax documentation. Do you need a date of death appraisal before selling? A date of death valuation matters because inherited property generally receives a stepped-up or stepped-down basis tied to fair market value at death, or, in some estates, the alternate valuation date. Does selling inherited property save time? Often yes. Skipping major repairs can eliminate weeks or months of work. The trade-off is usually a lower sale price, so heirs should compare the repair cost, carrying costs, likely sale price, and how much time the family actually has. Is there a legal deadline to sell inherited property? There is no single nationwide deadline to sell inherited property, but probate deadlines, creditor claim periods, mortgage rules, reverse mortgage notices, tax filing dates, HOA issues, insurance vacancy limits, and carrying costs can create real pressure to act. Every month the property sits unsold, the estate or heirs may keep paying the mortgage, property taxes, insurance, utilities, HOA dues, maintenance, lawn care, snow removal, security, and repairs. If multiple heirs own the property, cost sharing can become its own conflict. Decide early who pays the bills, whether those payments are reimbursed at closing, and who has authority to approve necessary repairs or emergency expenses. What should heirs do before selling inherited property? Before selling inherited property, heirs should confirm legal authority, title status, property condition, debt, insurance coverage, carrying costs, and any probate, trust, or TOD deed requirements. Once those issues are clear, the sale becomes much easier to manage. You know who can sign, what needs to be paid off, what the property is worth, and whether the fastest path is a normal listing, an as-is sale, or a more structured probate or trust sale. If you inherited property and need help finding a broker who understands estate-related sales, Inherited Property Match can connect you with a vetted broker experienced with inherited property. The match is free. You can also read the full timeline guide and more inherited property resources at inheritedpropertymatch.com.